Is it an exaggeration to say that we are giving up quite a bit as consumers when we agree to these terms and conditions?
It is not an exaggeration, it's quite accurate.
Hey everyone, I'm Josh, and this is the In Your Corner podcast from CBS News Philadelphia. All right, think about every time that you have ever, I don't know, bought a new phone, maybe applied for a credit card, signed up for a streaming service. You almost certainly had to agree to some form of terms and conditions. The fine print, the stuff that most of us probably never actually read. And that's not hyperbole. Pew Research tested the theory back in 2019 and found 98% of respondents agreed to a fake consent form that offered the naming rights to their firstborn child. Oops. But in reality, those small words, well, they can wind up costing us big time. In fact, just recently, Ticketmaster came under fire for adding some new language to its terms and services. It basically blocks users from ever being able to band together in a class action lawsuit. Comes after customers impacted by a data breach in 2024 filed a class action suit against the company. Now, for its part, Ticketmaster has said the changes were made for clarity and that those provisions they've been included for many years. But either way, as consumers, what rights are we giving up here just to do business when we hit accept? And what can we do to maybe better understand what we're agreeing to without needing a law degree here just to decipher it? Well, here to help us out with that is Christine Hines. She is a senior policy director with the National Association of Consumer Advocates. Christine, welcome.
Thank you. Thanks
It,
for having me.
it's so good to have you here. You made the trip from DC, and we appreciate that. So, look, while the rest of us barely have ever read the fine print is your job.
Yeah, it is. It is unfortunately it is but it's worth it. The fine print is so pervasive for us. And you mentioned, not having a law degree, and we shouldn't have a law degree for, when we buy products and services. Really, we care about the price and what the product is, and that's really what we should care about. But more is happening. There's more in the fine print that's really taking away our rights and protections.
Well, so is it an exaggeration, generally speaking, to say that we are giving up quite a bit as consumers when we agree to these terms and conditions?
It is not an exaggeration. It's quite accurate to say that. We're giving up, well, I don't like to put the blame on the consumers. I don't say that we're giving up, but what's being taken away from
Mm,
us when we're placed in this position because we really don't have a choice if we want really essential products and services. But what's happening is that the fine print is taking away our key rights, such as things that we think that we have, our right to go to court, our right to resolve claims fairly in court, our right sometimes to privacy. The fine print has suppresses protections that state legislators might give us or Congress might give us. The fine print will waive those rights, so we don't even know. We might not read it, we might not see it, we might not even understand it. And even if we did, I mean, why are we going to give up that product or service because it's everywhere?
right. It's like a catch 22, right? Um, Either you give it up or you don't get the whatever you're trying to get.
Exactly. It's just that's not the way it should be because when we buy something or we engage in something or we download an app, we're download the app and it should be about the product. It should be about the service and the cost is the cost,
Mhm.
but the cost shouldn't include our like, fundamental protections given us by the Constitution and by our state legislators.
Yeah, I mean, I'm sure in some cases I would be absolutely mortified at like what I'm allowing a company to, sell in terms of my data, right, or collect it. I mean,
Yeah.
some of these companies basically have entire profiles on us that they can sell and make money off of, right, for advertising and other things. And
That's true. Recently, well, just this week, we heard about the company Roblox,
Mhm.
and it's an entertainment game platform, and they they were sued by parents of a kid, and they because they were apparently collecting data and secretly collecting the data of the child, and collecting data of many kids, and so the parents were filing a class action for their kid and for many kids, but then it turned out that there was an arbitration clause in that Roblox
Mm.
contract. And essentially, the court said that they have to go to this private arbitration process and they could not go to court to discuss and to resolve this disputes over whether their kids' privacy rights were being violated.
Okay, so this common occurrence now in a lot of these terms and conditions is this idea of you taking away your right to go to court. Is this the term that's known as like a forced arbitration? Is that what that means?
Yes, exactly. It is a forced arbitration clause. So these terms are in so many fine print contracts. And what it does, it says that it takes away your right to a civil jury trial. And it says that if you have a claim against us or you have some dispute against us, you have to go to a private proceeding called arbitration, and it will be you won't have a judge or a jury. You'll have to go to a privately hired arbitrator, and they will write the rules, and they'll run the process, and then when it's done, it's final, and you don't have a right to appeal. And so people assume that we have we have a constitutional right
Hmm.
to a jury trial, and that's really suppressed and taken away in so many consumer contracts.
So basically, if you ever want to go and hold a company liable for, I don't know, a defective product, fraud, workplace injury, whatever it may be, this is a shield for them to avoid that liability.
Yeah, as long as it's attached to a contract,
Hmm.
most contracts, I always think about in financial services. I mean, it's really, really prevalent in financial services and products, credit card companies and payment apps. And if there's fine print attached to all of them, and most of them use these arbitration clauses. So when they're cheating, if they're charging fees that are illegal, or deceiving us and saying they're providing us with this service, but they're not providing that service, then we have. I mean, if we are going to resolve the dispute, it has to go through this individual arbitration process.
In 2019, there was a study from the University of California, Davis, that found, putting these clauses into the fine print of their terms and conditions, um, that they were able to do this. 81 of the top 100 companies did this without fully informing consumers that they were even doing this. And this is a process that, doesn't it kind of historically, notoriously favors the companies?
Favors the companies because they write the rules. They write the rules. They write what's in the contracts, because remember, we don't negotiate these. We don't negotiate the fine print that comes with our products and services. We either we take it or leave it. We take the product or we leave it. And so this is where we are.
So you mentioned Roblox. There was also another, I think, pretty well-known example of forced arbitration, and that sort of caught my attention several years ago that I started really digging into it. The Disney Plus example. Can you kind of run our viewers through what the gist of that
Oh
was?
yes. Okay. So Disney, Disney got a lot of attention over this. So they had a couple went to Disney World and went to a restaurant there. Apparently, these were the allegations, gave notice to the restaurant that the woman, the wife, so husband and wife, that she was allergic, and gave a lot of notice, and she had an attack, and she died on the premises. Her husband filed suit against Disney,
Like a wrongful death
a
lawsuit?
wrongful
Okay.
death lawsuit against Disney, and then Disney asserted that he or the couple had um, registered for Disney Plus, like a trial subscription. And with the Disney Plus subscription, of course, Disney Plus comes with fine print. And in there was an arbitration clause and class action ban. And Disney wanted to use that fine print contract and that arbitration clause that would prohibit him from going to court to vindicate the rights of himself and his wife. When the news broke, there was a severe public backlash. And what was really kind of insane was that, they were at the park, and Disney owns a lot of products and services that millions of us use.
Sure, yeah.
They have streaming services, they have the park, they have broadcast. So
Cruise lines, yeah.
Cruise lines. So the terms they apply across all of the products, even though each one comes with
Its own.
its own. But that was what they were trying to do. And after the backlash, Disney relented and allowed him to go to court to settle his claims on behalf of him and his wife. But the reality is that Disney, it's great that Disney relented in this one case, but the fact is that every product and service that we use with Disney, millions of people are still subject to Disney's arbitration clause and the other terms that might restrict our rights. So
It's just wild. So his wife suffers this deadly allergic reaction at a Disney restaurant. He files wrongful death lawsuit, and they come back and say, this free trial that you signed up for years ago bars you from being able to sue us. I think most people would probably be like, wait a minute. Most people were.
And I think it also highlights the fact that, it is an issue of very, very large companies that hold so much power over us. So there are even fewer terms and conditions because we have very large companies that can impose these restrictions on us. Disney's is one, but also, you mentioned Ticketmaster is another one. A very large company that has a lot of power over ticket sales, the whole market. It also has power over the venues, and so a lot of the venues, and it comes, any interaction that a lot of us have with going to a concert or going to a a soccer game.
Yeah, you got to deal with them, right?
You got to deal with the terms and Ticketmaster's terms and conditions. You got to deal with them saying that you can't do this, you can't do that in terms of your constitutional right to go to court. You can't I think that they also have restrictions on damages where you might have a state law that says you're entitled to this or this. The terms will kind of limit those rights and remedies for you. So I think that when you have very large conglomerates, it just it emphasizes the problem too, because they can just whisk it out for this product or service, and they have many products and services that they are.
So how do us as lowly consumers then take on these massive corporations?
So yes, I think that one is to go to our lawmakers. Only Congress, arbitration itself is a federal issue. So only Congress can pass a law to ban arbitration. On the state level, people can look at other terms and conditions that are unfair. The other action item, when we find ourselves in in trouble with their product or service, then we should turn to officials that we know can help us, our state attorney general, or complaint. There are agencies that have complaint systems, like the Consumer Financial Protection Bureau. Complain to them when something is going wrong. You think that you've been cheated or ripped off. Complain. You know, a public backlash is good. It helps individuals. It might not help the system,
Sure.
but it does help individuals when something happens that we complain about it and make it known.
I always recommend people file a complaint with the state attorney general. They all have consumer divisions, and while I think it can feel um, sort of like it's going into a black void somewhere, the reality is that right, the more people who report something, the more that a company or a practice comes up, that's when maybe they can build a case, but they can't do it if no one's going to report it, right? And they can't track it.
Exactly. No, there's always, so when something goes wrong, I find in consumer, with consumer products and services, when something goes wrong with a company, or a company treated you in a certain way, it's likely that they treated other people the same way.
It's not an
it's
isolated
it's not
incident. Yeah.
it's not just you. And so, if you're complaining, some others are probably having the same issue, and that would, motivate maybe the state AG, or some other official, or it would become more public, so maybe you'll be able to band together somehow to get some justice. But likely you're not alone when something goes wrong with a company, especially large ones.
So you're on Capitol Hill. You're lobbying with these lawmakers. What is the solution here? Is there legislation, and if so, where are we at with that legislation? Because notoriously, right now, there isn't a whole lot happening in Congress.
So, yes, there is the FAIR Act, which is the Forced Arbitration and Justice Repeal Act for arbitration. And so that would solve the issue in terms of giving, it won't get rid of arbitration, because that's not what we're trying to do. We
Mhm.
just want to make it voluntary, meaningfully voluntary. So that means that if you want to go to arbitration, that you get to choose after the dispute arises. So it doesn't depend. So it will just remove it from the fine print, and then when the dispute arises, you complain to the company, and you get all your ducks in a row, or a consumer gets all their ducks in a row. They can decide to go to court, which a lot of us would do that,
Mhm.
or they could decide to, they want to just keep this quiet, whatever the case is, but they get that choice after the dispute arises.
Where does that bill stand?
So, well, the bill has a lot of support, um, but I don't think that. I hate to be a pessimist, but I
Oh
think
no,
I think
please
it's
do.
I think it's an uphill battle. I think it's an uphill battle for it at this moment. But I think that there will be a point when, we're ready for it to be passed.
You say pessimist, I say realist.
Yes, maybe.
I mean, can we just pass a bill that would they have to simplify the language at least? Like we don't need a law degree to read these things? Probably
Well,
not, right?
yeah, so we don't, right. I think that if it's about simplifying language, I think that still doesn't get to the meat of the problem, the center of the problem, because the center of the problem is, if it was in the simplest form, they can still tell us that they're
Sure.
taking away our right to jury
Sure,
trial.
well,
They
that's
can
true.
so simplifying it, I doesn't get to the meat of it.
Well, maybe not simplifying it, that's true, but can we maybe place, you talk specifically about forced arbitration, but can there be limits placed on other things that they might ask us to waive, or rights they might ask us to waive, or what they say they're going to collect on us?
Oh, well, yes. So if they're, I agree with that. I think that, states have, outside of forced arbitration, that our state legislatures, and I think we have more influence over our state
Hmm.
legislators than with Congress, and they have the power to maybe include or require companies not to waive our substantive rights, not to waive our right to remedies, and not to waive if our state has different laws and gives us different protections. A state can say you can't waive your protections in a fine print contract, for example. So of course that does not include arbitration clauses, which is the worst one.
Hmm.
But there are other rights and remedies that a state can protect from the fine print.
Well, okay. So in the meantime, maybe we can't, simplify the language, but we can better understand what is in there because some of it gets into legal jargony
It
nonsense.
it does.
Uh,
You're so right. You talk about needing we shouldn't need a law degree to understand terms and conditions when we sign up for different things. I mean, we care about the product or the service, and we care about the price, and the use of the product, and but the other things that are in the contract um, are for the benefit of the company. That there are companies that will also include provisions that say that they will preserve for the court for their own claims. So, for example, with some just thinking about like big tech, they will protect their copyright and protect their intellectual property and say, so if there are any intellectual property claims or if there are any copyright issues between us, we can go to court because they know the company is likely to have those claims, not the consumer. So they preserve those, the claims that they think that they will have. They will protect those and ensure that those will go to court. But everything else would have to go through arbitration.
so AARP put out kind of a helpful list on like common terms that come up often in these contracts, and like if you're going to know any of them, you should maybe know these ones.
Yeah.
One of the big ones that always comes up is opt out.
Yes. So an opt-out provision in a fine print contract. Let's talk about arbitration again.
Okay.
So some companies, they will put an opt-out provision that says that you can opt out of this arbitration clause. You have to do it within 30 days of signing up for this product or service, and then you have to mail it to us in Times Roman 12 font.
Right.
So
Yeah, yeah.
so it's not like you said, most of us are not reading or understanding the terms of the fine print. So an opt out, in my view, is a lot of the times meaningless. Or they are meaningless. The opt out provisions. I recall opting out of a credit card forced arbitration clause many years ago. I know. I'm pretty sure that I'm now subject to the arbitration clause because the fact is, companies can change their terms anytime they want. They can change the terms of service anytime they want.
Even after we've agreed to them.
Yeah. So they can change it unilaterally. That's another issue is that they can change their terms unilaterally without really our consent. They're like, again, take it or leave it. And so my opting out years ago with a company, and I went through the exercise just to do it. But I'm pretty sure like years later they changed their terms. I'm now
That would
subject
render
to
it
the
moot, basically.
that would render it moot.
Oh, well, that's lovely. All right. What about, so we talked about forced arbitration. What is mandatory arbitration?
It's the same thing. Forced arbitration is when the companies use a fine print to force you into arbitration when a dispute arises,
Hmm.
and mandatory arbitration is the same thing. It's
Okay,
just
just
another
by a different name.
synonym. Yeah.
And then a class action waiver. Does that also kind of fall under that similar?
So a class action waiver, which I like to call a class action ban, because a waiver to me sounds like it's voluntary when when it's not. It's not voluntary. We're being forced into these things. So a class action ban or waiver, you'll see class action waiver in the contract, means that consumers or workers are not able to band together in class actions when they have similar claims. So, for example, in the case of the Roblox that we talked about earlier, where the where the parents are they filed a class action on behalf of their child, who they thought their Roblox was kind of invading their privacy, or that they were representing other parents and other children as well, to because if Roblox is doing one thing to this one kid and taking, away their privacy rights, then it's likely that the company is doing to others.
Well,
Um,
oftentimes it's not feasible as an individual, right?
it's
Sometimes to bring a suit against, and so the class action is kind of the only way to do that.
Absolutely.
Yeah.
It's if a company, if a financial services company is charging you a $30 fee, like Supreme Court had decided, and that if they charge one person a $30 an illegal $30 fee, is somebody going to go to
Right.
court over
Yeah.
that $30? No. So, but the company's probably earning millions
When you add it
from
all up.
charging other people that $30 fee, and so the class action is the best way to hold that company accountable.
Well, while the rest of us aren't reading it, Christine Hines is making it her daily job to read the fine print and to find ways to better protect us from it, and we so appreciate it. Christine Hines. Thank you, Christine.
Thank you, Josh.